Welcome. It's another busy week at the National Right to Work Legal Defense Foundation. Let's begin with a petition in the U.S. Court of Appeals in light of the court's recent rejection of Obama's unconstitutional National Labor Relations Board appointments. Since the foundation won U.S. Supreme Court victory in Communication Workers v. Beck, courts have held that workers who refrain from full dues paying union membership cannot be compelled to pay for union political spending, lobbying, member-only events, and similar non-representational activities. National Right to Work client Jeanette Geary, a former Warwick, Rhode Island nurse, filed a federal unfair labor practice charge against a local nursing union for illegally forcing her and other employees to pay for the union's lobbying or lose their jobs. In 2012, the board held that the union hierarchy could force the nurse and her coworkers to pay for the union's lobbying, including political lobbying in the state of Vermont, but asked for further briefs before it issues an appealable final order. Foundation attorneys filed the last resort petition for a writ of mandamus or prohibition, asking the U.S. Court of Appeals for the District of Columbia Circuit to bar the NLRB from further action in the case until a valid board is seated. The petition was filed in the wake of the court's ruling last month invalidating President Barack Obama's controversial purported recess appointments to the board. The court held President Obama could not constitutionally make those appointments without U.S. Senate confirmation because the Senate was not in recess. National Right to Work Foundation staff attorneys filed a brief jointly with the Landmark Legal Foundation in the case. Mark Mix, president of the National Right to Work Foundation, said, "Jeanette Geary's case is just the latest example of how independent-minded workers have received unjust treatments at the hands of Obama's illegal pro-big labor NLRB. The board must cease its illegal activities, expanding union boss powers in the face of long-held Supreme Court precedent and constitutional case law prohibiting union bosses from taking workers' dues for union politics." Mix added that the extraordinary circumstances involving Obama's out-of-control NLRB, which has already proceeded to ignore the appeals court ruling, has created the urgency for Foundation staff attorneys to employ an extraordinary legal move to halt the board's unconstitutional actions. In Wisconsin, the legal smoke has yet to clear since Governor Walker's Act 10 was passed by the Wisconsin legislature. 3 Wisconsin public school teachers filed a brief in the Wisconsin Court of Appeals last week supporting Governor Walker's public sector union reform bill, known as Act 10. Ellenbrook School District educator Elijah Grajkowski, Kenosha teacher Christy Lacroix, and Waukesha High School teacher Nathan Barish filed the amicus brief with free legal assistance from the National Right to Work Foundation and the Wisconsin Institute for Law and Liberty. In their brief, the teachers argued that the Wisconsin Court of Appeals should overturn the lower court's ruling that Act 10 is unconstitutional. The teachers' arguments in the brief rely on precedents long established by National Right to Work Foundation 1 cases at the U.S. Supreme Court, as well as recent Foundation-supported victories at the U.S. Court of Appeals for the 7th Circuit, which upheld all of Act 10, and the U.S. District Court for the Northern District of Indiana, which upheld Indiana's recently enacted right-to-work law. Meanwhile, 2 other Wisconsin public servants, Christopher King and Carrie Kendrick, have also filed an amicus brief for opposing a union legal challenge to Act 10 in another federal court. In Los Angeles, California, with the help of National Right to Work Foundation staff attorneys, KTLA-TV sports reporter and weekend anchor Rebecca Hall has filed federal unfair labor practice charges against the Screen Actors Guild, American Federation of Television and Radio Artists Union, for attempting to force her to join the union and pay full dues. SAG is the monopoly bargaining agent for KTLA-TV, which means employees can be forced to pay union dues to get or keep a job with the station. Under federal law, however, employees cannot be compelled to join the union or pay union dues for things unrelated to workplace bargaining, such as members-only events and political activism. Despite these prohibitions, SAG officials demanded Hall become a full union member and pay excessive initiation fees and union dues if she wanted to keep working at KTLA-TV. Union officials failed to notify Hall that she could opt out of dues unrelated to workplace bargaining and never provided her with any information about union financial expenditures information that is required by law to help non-union workers determine what dues they can be obligated to contribute. When Hall declined to join or pay up, SAG union officials threatened to have her fired for refusing to comply with their outrageous demands. And in Providence, Rhode Island, with free legal assistance from National Right to Work Legal Defense Foundation staff attorneys, a Rhode Island School of Design technician has won an informal settlement from a local union for violating his rights. The settlement stems from a federal unfair labor practice charge. Robert Venerbeck of Providence filed with the National Labor Relations Board Regional Office in Boston against the RISD Technical Association Union, an affiliate of the National Education Association Union. Venerbeck resigned formal union membership and revoked his union due deduction authorization, a form used to take union dues from workers' paychecks. The U.S. Supreme Court has long held that workers have the right to refrain from full dues paying union membership. Because Rhode Island does not have right-to-work protections making union affiliation completely voluntary, workers who refrain from formal union membership may still be forced to pay part of union dues to keep their jobs. However, non-member workers cannot be required to pay union dues spent for union political activities and member-only events. Venerbeck charged that union officials refused to follow federal disclosure requirements outlined under Supreme Court precedent despite Venerbeck's repeated requests. In addition, the charge filed with the NLRB stated that union officials refused to provide him with an independently audited financial breakdown of union expenditures and the opportunity to challenge before an impartial decision maker the amount of forced union fees he must pay. In late September, union officials demanded Venerbeck be fired from his job in an apparent attempt to retaliate against him for exercising his rights. The settlement waives all back union dues claims from the past 2 years, rescinds the union boss's demand to have Venerbeck fired from his job, and requires union officials to post a notice in the workplace informing workers of their right to refrain from union membership. RISD Technical Association union officials were forced to back off from their intimidation and threats towards a worker who had the temerity to not toe the union boss line and pay for their political agenda, said Mark Mix, president of the National Right to Work Foundation. Rhode Island desperately needs a right-to-work law, making union membership and dues payments strictly voluntary. Well, that sums up another busy week at the National Right to Work Legal Defense Foundation. Thank you for watching, and for more information about these cases and others, visit www.nrtw.org.